Welcome, everybody, to this webinar, The Judiciary's Role in Protecting the Environment. And we are very fortunate today to have special guests who will talk to us about the role of the judiciary in addressing climate change, as well as a variety of issues concerning how judges should approach environmental cases and how students, law students and others interested in the work of the judiciary can pursue their environmental values. There's so many things to deal with in today's climate that we're very fortunate here at George Washington University School of Law to have very many energized and engaged environmental law students and alumni, two of whom are here today. But let me also turn this, so today what you'll hear is concerning the climate crisis. And today you will hear from a current judge on one of the only two specially designated environmental courts in the country about his experiences and his approach to judging. And two former clerks now are working to fight for a healthier environment, and they will share how they navigated the clerkship process and used it as a launching pad into environmental careers. So I know that the students watching today will be very interested in this panel. Without further ado, I will turn it over to James Crisafulli, who organized this event, and James can introduce you to our special guests.
Thank you so much, Professor Harmon Walker. Very excited for the event today. My name is James Crisafulli. I'm a 1L at GW. I'm interested in and passionate about environmental law and environmental justice, and honored today to host this event and moderate this event. Our first panelist is a very special guest, Judge Jeffrey Crabtree, who I'm gonna speak with and ask some questions to. Judge Crabtree became a First Circuit Court judge in 2014. And before becoming a judge, he practiced civil litigation in Hawaii for over 30 years. Judge Crabtree has presided over the domestic violence trials calendar and the felony trials calendar. And as of April 2017, Judge Crabtree is assigned to the Civil Litigation Trials Division. Effective in August 2017, he was designated as the Senior Environmental Court Judge for the First Circuit. Again, one of the only two environmental courts in the country. And he grew up in Hawaii, attended Williams College and the University of San Francisco, and got his JD from NYU in 1979, and practiced in Boston and New York City before coming back to Hawaii in '83. So I'm honored to welcome Judge Crabtree. Thank you so much for being here.
Oh, thank you. Happy to be here.
So my first question for you, and we do have two other panelists, but I will hold off on introducing them until they speak, but excited about them as well. So first, Judge Crabtree, again, this environmental court that you sit on, one of only two in the country. Can you explain why Hawaii has an environmental court and what exactly it does?
Sure. I think it starts with our Constitution. We're one of the few states that actually has an environmental protection provision built into our state constitution. And it's very brief. I'm going to read it because it'll give you a taste of why we have an environmental court. This is Article 11, Section 1. For the benefit of present and future generations, the state and its political subdivisions shall conserve and protect Hawaii's natural beauty and all natural resources, including land, water, air, minerals, and energy. And it goes on to say a few other things. And then says all public natural resources are held in trust by the state for the benefit of the people. That's about as broad a environmental protection that I think you can find in any constitution in the United States. And so it sets the tone. And building on that, we in 2015 enacted a law that created the exclusive and original jurisdiction of the environmental court. And the stated purpose of that law was, I'm quoting from the legislative history here, to promote and protect Hawaii's natural environment through consistent and uniform application of environmental laws by establishing environmental courts. So the very simple premise was environmental law is important to Hawaii. We're going to focus on protecting our environment, and to do that using rule of law approach, it's better to have judges who are more familiar with the environmental laws than if they were just randomly being assigned on a general civil calendar. So that's the background. It's not terribly complicated. It really boils down to, if you have something important you want to do, assign judges to do it on a regular basis and train them.
Right. Sort of a practical consideration. Yeah.
Right.
And I think that's fascinating about the Constitution as well, especially with now we're seeing many more, plaintiffs or youths asserting a constitutional right to a healthy environment, and that kind of the movement for that growing. So yeah, I'm curious then, how did you end up becoming a judge on the environmental court, and what your experience has been like so far in these few years?
Okay, well, point of clarification. A lot of people think I'm a judge of only environmental cases. I'm not. I have a general civil calendar. I have approximately 600 cases assigned to me, everything from minor business disputes up to $100 million class action type of cases. And then I'm in my office working away one day, and the phone rings, and it's our Chief Justice, Mark Rechtenwald, who's a serious environmental concerned person. And he said, Jeff, I'd like to appoint you to the environmental court. So that's how I got appointed. We're not elected, we're appointed judges. And once we become a member of the judiciary, then the Chief Justice really controls who goes where. So I didn't volunteer, I was voluntold. But I'm glad CJ did that. It's been a great experience for me, honestly.
Yeah, could you share some of your main learnings from your time on the court so far?
Yeah, sure. I mean, one of the questions I get a lot is, did you have any environmental experience whatsoever before being appointed to the position? And the answer is no. I did a lot of civil litigation for 30 years. I never handled a single environmental case. And so you talk about a learning curve. Yeah, it's been pretty much straight up. But, I think most judges, I think, like a challenge like that. We like having new things we have to figure out and stretch and learn. And so that's what it's been like for me. I mean, every new case that comes in, I'm pretty much starting from scratch, and I do what all judges do. I read the statute, I read the main cases, I read the briefs, and I try to figure it out. So that's pretty much my training. And, after having done it for years now, some of the cases obviously are looking more familiar than the first time I had one. And so it's easier, which is exactly what this law was designed to do, to create this court. I'm getting better at it the more time I spend with it. So.
Right. Yeah. So sort of accruing more expertise over time.
Exactly.
So then, with the cases that you have heard on the court, what are some of the most common types of cases that come before the environmental court specifically?
Well, public trust cases, of course. That's one of the reasons I read the constitutional provision to you up front, because it's the bedrock of many of the cases that come before me. But more concretely, we have a lot of legacy issues that are continuing to the present concerning the use of streams or water out of the streams. Who gets to take the water and for what? It's a major issue in Hawaii. It has been for a long time. It still is. And a number of the cases I'm working on involve that issue. Because, it's not as easy as keep all the water in the streams. I mean, you have agricultural uses, you have residential uses, you even have cultural practitioner uses. So it's a nuanced issue for sure, depending on whose lens you're looking through. Another thing is we've had a number of cases stretching back years involving the taking of aquarium fish for aquarium collectors. And to what extent an EIS has to be done, and are they sufficient? So it's similar to the federal process in that we have EAs and EISs. And so I spend a lot of time reviewing those. We have cultural protections in Hawaii. The ancestral bones are literally everywhere. Some places more than others. For instance, Waikiki, the site of many, many old burials because it was sandy, it was soft, it was easy to dig in. So if you're building a hotel and you digging a trench and you come across human remains that look ancient or at least aged, a huge environmental process kicks in. You basically shut down the work. You have to do an inventory. You have to carefully dig around and inspect to see how many more remains there might be. You consult with a council of elders, so to speak, who are Hawaiian cultural experts on the best way to redress, leave the bones in place or remove them somewhere. So that's, I have a number of cases involving those issues. Wind turbines. Can you build a wind turbine without endangering a species? That's come before me. And then, of course, most recently, shoreline issues. Our ocean is taking homes right now. I'm sure you're aware of other places in the country where it's happening as well. So there's a lot of effort going into how do we ameliorate, but also how do we protect the public trust, which is the beach. So you can't just build a seawall to protect your land if you're going to wipe out a beach doing it. There's, but you obviously have some empathy for the homeowners too. So it's not an easy issue. So that's a non-thorough list of some of the cases, just to give you an idea.
Thank you. Yeah, and definitely conveys the wide variety of types of cases, and both in terms of topic areas, but also judicial issues that you might hear. I'm curious with you talked about the expertise accruing over time and becoming more familiar with the law and how to hear some of these cases. What level of technical or scientific expertise do you think is either necessary or helpful for a judge in an environmental case to have, or for a litigator in an environmental case to have?
That's a really interesting issue. I've spent hours of quality time thinking about that. I don't have a firm answer yet, but I might have just generated more questions for myself. So I'll dive in and see where it goes. I mean, at first, I certainly don't want the headline to be "Judge thinks science not necessary." Okay, so let's be clear about that. But as a judge, I'm supposed to decide cases based on what's in the record, what is brought before me. And so what happens if I'm deciding cases based on some external knowledge or training that I got that the attorneys don't know anything about? That's not right either. That creates some real problems. So I think over time, my thinking has evolved, and I in a way, I liken it to a lot of my cases where there's a scientific issue that either me or a jury needs to get educated about. And we do that through expert witnesses, right? You bring in your expert witness who explains why the eye infection wasn't treated properly. And if it had been treated in this way, the patient would have kept their eyesight. Well, is it really so different with climate issues? I'm not so sure. An expert comes in and explains, okay, here's what's going on. Here's what we need to do about it. And I take that factual basis and I apply it the same way I would in any case, as opposed to having my own external knowledge about it that I'm applying without anybody really knowing what I'm doing. So I mean, training, yes. I think the more a judge gets some training on some of these issues on a broad basis, obviously, the better he or she is going to be. They're just going to be a little more fluent in the whole topic. But I think ultimately, in terms of litigation, you have to be really careful about giving a judge a lot of special training, at least not without a lot of rules on disclosing it, so the counsel have a chance to address it. I mean, what if I'm being taught something that's wrong or outdated? Not fair to the parties to have their case judged by someone who's relying on things that are either inaccurate or outdated. So,
Yeah, no, that's fascinating. Treating it sort of like other cases where you want to avoid judges bringing in personal knowledge or biases, and it's the litigator's job to educate the judges and or make the best arguments. So I wanted to, you've mentioned a couple of times sort of, doing as any judge does, or looking at the statute and approaching sort of environmental or climate cases in that similar way. I was wondering if how you would describe your approach to environmental cases and specifically climate related cases, and if it differs at all from another case, or if you do really try to approach it like any other case.
Okay, I mean, that question right there is probably the reason I agreed to do this, because there's an important message that I wanted to get out, that every time I speak to a community group or a law group of some kind, I make this point. And sometimes people get really angry with me, and sometimes they understand it is what it is. So I'm just going to put it out there. I do not approach an environmental case any different from every other case on my docket. The environmental court is not a environmentally friendly court. I'm not the Environmental Protection Agency. I wait for cases to come to me. When they come, I decide them. I decide them based on the facts, on the law, on civil procedure, on the quality of an expert witness, maybe, that we just talked about. But I'm not looking for a pro-environment outcome. I just don't think judges can do that. We already have implicit biases that aren't always easy to deal with. So if we start having explicit biases, that's really a problem. So I say it all the time in my court. Sometimes the environment wins and sometimes it loses. But that's the job. And so what I constantly want to make clear to young attorneys or law students is, it's great to have passion, for sure. I'm totally for passion. But I mean, that's a mindset, which is okay, great to have. But there's also a skill set that's maybe more important. So be passionate, sure, but also learn how to write well, learn how to argue well, learn how to litigate, learn how to be persuasive. Those things are also very important. Thank you.
Yeah. And I think, that role of a judge is similar to what you talked about with expertise and biases. The role of the judge is to apply the law to the facts. And that's, that shouldn't necessarily change between cases. You mentioned, you're not the EPA. I just wanted to ask how you see the role of deference to agencies to make some of these decisions.
Yeah, I definitely have. I have agency appeals involving environmental cases. I've been down that road a number of times, and I think Hawaii law is probably very similar to other places. I am supposed to give deference because the agency has in-house experts and expertise. They even have the ability to hire experts. That happened in one of my cases. The agency relied on an exhaustive expert report that it had prepared. But it's not a rubber stamp. Our law is very clear on that as well. It has to make sense what they did. It has to be reasonable. But I don't get to just say, okay, how would I decide this in the first instance? And that's the result. I have affirmed agency appeals that I probably may have decided differently if it was entirely up to me. But again, I'm just applying the law that we have. If the agency decision has a sufficient basis and it makes sense and it's reasonable given our law and administrative regulations, I affirm it.
I mentioned earlier when you spoke about the Hawaii Constitution, lawyers now and plaintiffs making these constitutional-based arguments, right to a healthy environment. And I've been really interested in, there's a lot of creative, interesting litigation out there, making persuasive arguments about tort law, contract law, different arguments, for protecting the environment. And I'm curious how you see how judges should approach kind of new and innovative ways of using the law, and how receptive judges can or should be to those kind of interesting approaches to litigating.
Well, I have to be very careful here because there's a current case where these issues are front and center that I really can't talk about. So I think I'm going to leave it at this, which is, it's really, I'm a trial court, right? When I have a brand new novel legal theory before me that our appellate courts have never addressed, I do my darndest to try and figure out, okay, I don't have any clear precedent. I don't even have any gray precedent. I have no precedent. So what am I going to do? I try to find guidelines. I try to find something that's in the same general zip code that our court has decided, and I work from that. And I just leave it up to the appellate court after that. I mean, I try to make a good record. I do my best to figure out what they might do, but I don't agonize over it. I just do my best to follow whatever guidelines are out there. But I cannot think of a single time where I had a novel legal issue that I could just pick which one I like the most, because there's always some kind of guidepost from our appellate court that I could at least try to follow. So that's what I do. It's really not my job to make new law. I'm very aware of that. It's my job to make a good record and let my Supreme Court or my ICA court make the call. Because all these cases, I mean, it's one thing on my regular civil calendar, sometimes I really am the last word because people just run out of steam at the trial level sometimes due to cost or fatigue or whatever. But all these big environmental court cases that I have, I'm not going to be the last word. I know that. So in some respects, my job as a trial judge is to just get it done on a solid record to give my appellate court their best chance to do what they need to do. So sometimes my job is just stay out of the way.
I had one final question before turning to the other panelists, which is particularly for students or recent graduates. I'm interested in clerking. When you are looking at clerks or hiring clerks, what do you look for in a clerk, and what makes a good clerk in your opinion?
Well, it really differs, I think, dramatically depending on what kind of clerkship you're talking about. I mean, in a classic busy state court trial judge like me and my brother and sister judges here in the state courthouse, it's really a different deal. Like I said, I have 600 cases. I have one clerk. It's not unusual. I had over, let's see, I kept stats on this. I think last year I had something like 800 motions. 800. So I am not looking, and I tell that I'm very upfront with my law clerk applicants. I tell them, look, if you want to hone your research and writing abilities, this is not the right clerkship for you. Go apply to an appellate court judge or a federal district court judge where they have more time to focus on each case. For a busy state trial court judge, it's about being able to work in chaos sometimes. Being able to turn on a dime because you come in expecting the day to be one thing and it turned into something else when a giant TRO lands on our desk at 9:05 and they need a big decision by 5 or else something really horrendous is going to happen. I mean, it's just a fire drill like most days. So I need clerks who can handle that environment. It's not for everybody. It really isn't. I mean, if you're a perfectionist and you want every single thing you do to be finely tuned and fully considered, and nope, this isn't going to work for you. We do the best we can given the resources we have and the time that we have. I think we generally do a good job, but the pace is crazy. So apply if you like working in a dynamic environment, as I guess the way you would put it.
Thank you. Yeah, well, that sounds very daunting, but I think that is very, very helpful for people looking for clerkships to kind of make that distinction, be able to know where they might best fit.
What you will learn a lot though is how to litigate, because you see it all. You see the finest practitioners. I mean, we have lots of cases with pro hoc vice attorneys coming in from the best law firms and biggest law firms in the world. And then we have, you know, frankly, attorneys at the other end of the spectrum. So you see a wide range, and it's a learning experience. But sorry, I didn't mean to take up more time.
No, thank you. Thank you. Well, thank you. I think our time is up. It's 2:30. Thank you all so much. I really appreciate you taking the time to be here, and I learned a ton from the event today. And just, yeah, really am grateful for you all sharing your insights. And thank you for everyone who attended. Hope you learned something. And thank you to the George Washington Environmental and Energy Law Program, Professor Harmon Walker, Professor Ellerts, for helping organize the event. That concludes the event for today. Thank you all for joining.
Thank you all. Yeah.
Thank you.
Thank you very much. Aloha.